Consider their decision as the country waits. What are the issues? A breakdown of what the bench will have to decide on. And the IEBC audits, a sneak peek at the registrars and the experts' report on election service. Hello, good evening. After an intriguing 2 days in court with top legal minds facing off before the 7 judges of the Supreme Court, the dust has now settled, or has it? The bench has retreated to its corner, and now the entire country awaits Friday's judgment. Will Kenya go back to the polls, or will Raila Odinga face yet another loss at the highest court in the land? To break down the case, we have former magistrate and advocate Joy Brendam Divo, as well as constitutional lawyer Jotham Arua, who will be joining us in a short while. Our senior reporter Sophia Wanuna, though, is still on the case and will bring us the latest in just a short while ago. In fact, we can go to Sophia now. Sophia, the judges are not in the court today. What is happening today? Where are they? What exactly are you hearing?
Good evening, Joe. The judges indeed are not here at the Supreme Court and nothing is going on. What we know is that they have retreated to deliberate and come up with that judgment that they are expected to deliver on Friday. And that is the deadline. It's the 14th day of that presidential election petition, 14-day timeline by which this matter must be heard and done with, as far as a judgment being delivered, Joe. So tonight, a quiet night here at the Supreme Court.
Now, yesterday, as they concluded the hearings, one of them, Justice Mohammed Ibrahim, wasn't there. He had been taken ill, and I wonder whether there's any news about him. But more importantly, what happens now? I mean, is he likely to rejoin the bench, or what do we expect?
We do not have an update in as far as how he is doing. Of course, we wish him a quick recovery. But we've spoken to various lawyers today, with various lawyers, and sentiments in as far as whether he can rejoin or whether he cannot are varied. There are those who opine that because he did not sit during the last day of hearings, then one of the parties could argue prejudice because then they did not get full hearing before this one judge for him to be able to deliberate and decide in as far as this petition is concerned. There are those also on the other side who argue that because largely the petition, the written submissions already had been made prior, and that is where the meat and the weight of the petitioner's arguments as well as the responses from the respondents lie, that whether or not he actually sat in court, that should not interfere with his ability to do so. But more lawyers appear to go with the first thinking, Joe, that really think that he was not there on the last day. And of course, because in open court, a judge always has that opportunity to engage with the parties as they make their submissions. If there's a clarification, which perhaps is not in the written submissions, the judge can follow up on that. But in as far as whether he will be part of now the rest of the 7 judges as they deliberate and deliver the judgment on Friday, we will wait to see, Joe.
Yes, indeed, and I'll be discussing that with my panel here. But one of the other things, Sophia, that I wanted to find out, I mean, the CJ yesterday didn't quite give a time on when the ruling might come. Do we have any sense, any indication at all what time on Friday we can be on standby?
There appears to be an indication of by a deadline of 6 p.m. we should have that judgment. And I say that, Joe, because a lot of attention throughout this presidential election petition has also been on the Chief Justice in as far as him being a Seventh-day Adventist, and that he had made clear even during the interview for the job that he would not sit or work on a Saturday. So we understand this marking of the 7th day day of the SDA begins on Friday at 6 p.m. through to the next day, Saturday at 6 p.m. So if that be the case, it means then by 6 p.m. beginning Friday, he would not be able to work according to what he believes is his religious beliefs and do not allow him to do the same. So Joe, from that, it appears likely that before 6 p.m. Friday, Kenyans will know which way the judges have decided in as far as the Raila Odinga Kalonzo Musyoka petition.
Great. We'll really have to wait and see how that pans out, Sophia. But finally, let me ask about those servers, those logs, those reports. There were quite some interesting development in the court. In the dying minutes of this case, the drama in court, quite frankly, about which report is which. Have you been able to clarify, and could you just explain to our viewers a little bit more clearly which report is which, and as the judges retire to consider what their decision will be, which particular reports will be before them?
Right, Joe, and a quick background of that is that these orders that led to these reports that were delivered in court yesterday were from that interlocutory application that was made by the petitioner. And in essence, Raila Odinga, Kalonzo Musyoka were looking to scrutinize the original forms 34A, B, as well as 34C, and also get access and a sense of an audit of sorts into the ICT aspect of this election. And that was able to take place in two aspects. The judges, in issuing their orders, remember the petitioner had asked for unfettered access. However, the judges, in as far as the ICT aspect is concerned, granted 19 orders in which then the first respondent, which is IEBC, President Kenyatta's counsel, as well as the petitioner's representatives, if you like, were to be part of this process. And what we can, going through that report that we've been able to get, is see there were various areas where they got access, as was ordered by the court, but in several areas they were denied access, or access was not granted, is the wording in that particular report. And this is according to the court-appointed IT expert that was overseeing that exercise. And of course, as well, there's the findings from the scrutiny of the forms 34A, B, and C. And the registrar of the Supreme Court oversaw that particular exercise, and some of the notes she makes in as far as the scrutiny of these forms is that in some forms there was no evidence of there being a signature or a stamp by the required officers, as the RO or PO in some of the forms. Then appeared to be photocopies, some of those forms. Others appeared to be carbon copies, as well as others appearing to have been duplicated. These were notes that were made in that report by the registrar of the Supreme Court. So some of the findings, Joe. Now, why there's a bit of a concern about which reports were actually admitted and which judges will be looking at is because you remember, after these reports were presented in court, the petitioner's lawyer, that's James Orengo, sought to introduce two other documents from the representatives of the petitioner that were in both the scrutiny of the forms and the ICT access question. However, that was strongly opposed and objected to by the other lawyers from the respondents, and the judges also said that he could not at that point file or even serve other counsel with those additional documents. And in essence, these were findings of their experts or their representatives as the petitioner. But it was also interesting to note, Joe, during those proceedings, that also lawyer for President Uhuru Kenyatta, that's Fred Ngatia, also in responding to this report, talked about annexures from their experts as well. That we also saw counsel Orengo strongly opposed to the same, saying he should be also granted the same treatment to restrict himself to the reports. So how to know which reports the judges will be considering finally, Joe? It is those that have and bear the stamps and signatures and the header of the Supreme Court here, the registry of the Supreme Court, the registrar overseeing those, and the court-appointed IT expert. All these others, and a lot of them have been doing rounds on social media as well, should be treated with a pinch of salt because those are not before the judges.
All right, thank you very much, Sophia. Obviously, each side trying to control the narrative here, of course, even as the country waits that important ruling on Friday. Sophia Wanuna keeping an eye on what's going on with the case, where the judges might be, and some of the things that they might be considering. I can now introduce my panel, or shall I say reintroduce my panel. Joy, thank you very much. Jotham, the both of you, of course, have been with us. We truly appreciate throughout this coverage. And some interesting things that my colleague Sophia Wanuna raised there. One of them is with regards to Justice Mohammed Ibrahim. I mean, he wasn't there yesterday. The CJ reported in the morning that he was unwell. We have no information on where he is or what's going on, and obviously we wish him a quick recovery. But in that event that he is better now, can he rejoin the rest of the judges to sit and to consider what their decision will be in the end?
My considered opinion is that he would be able to rejoin them because he started off with them. And remember, the preparation for this hearing did not start at the hearing. It started once the papers were filed. So the judges have been studying these documents and have been going through them. So 1 day of absence for medical reasons is not enough to stop the proceedings, because the proceedings must go on unabated. And I do not think also disqualifies him from joining his brothers. Maybe he was with them today, we do not know, because they've been sequestered for this season. So I would not be surprised if Judge Ibrahim was sitting with the
nobody
bench
would say
on Friday.
Prejudice because he didn't.
In what
listen.
sense? He is a judge. He's not one of the parties. He was not leading any evidence. And the fact that the judges consider the position together, if he needs any appraisal, he will be appraised, because
So you'll be able to read things, transcripts, things like that? And
most probably. And if you see what was done on the first day was quite substantial. So the bit that he missed, maybe the technical bits and the others, even the other judges will be getting input from the experts and the others, which is what will be happening today. Probably tomorrow is when they'll be getting down to writing the judgment. So I do not think that it would jeopardize the hearing in any way. But be that as it may, if he finds that he cannot rejoin the bench, again, we need a minimum of 5 judges. We still have 6 judges who have been hearing the matter.
And I'll come back to the number 6. But Jotham, is this a question that should even be arising at the moment?
Well, it is not, in my view, a very serious question, if you ask me. The truth is, the judge has been part of the bench from the beginning. And in a presidential petition, almost every process is regulated. And by the time you go for what is called the pretrial conference, all the documents that ought to be filed basically are in. And by that time, the judges should have familiarized themselves with the case to a point where they are able to handle it. And I therefore believe that he has had sufficient interaction with the case to justify his involvement at any stage that he gets better.
So for those who may not understand, what is the weight that the judges attach to the written pleadings, the things that are filed in court, vis-a-vis the oral presentations that all of us love to watch? Is there any that is more important than the other? Are they part of it? Can you do without any of them? How does that play?
Ideally, you're supposed to confine yourself to the written submissions. The reason why the submissions are written is because of time constraints. It may not be possible for you to tell everything that you may want to, every information that you may want to share with the court. And so you write it down. So when you are given time to highlight it, it is just for you to pick up the critical areas that you would want to emphasize. So ideally, you are supposed to confine yourself to what is already written down.
So what's the place of the oral submissions? What do they do?
The oral submissions are important in trying to pull out what you want the judges to really pay attention to in the written submissions. Like my colleague says, when you have written submissions, sometimes you throw in the baby and the bath water in there. You know, you write every single thing. We've had, for example, in the past, in the 2013 petition, the 900-page affidavit. Now, if you've got 2 days to go through something, you're not going to read the 900-page affidavit. You're going to go to the paragraphs, and that's why I kept hearing the references. If you look at page this, my lords, if you look at paragraph this, my lords, because there are those points where you really do not want them to miss. And so you go ahead and lay emphasis on those particular points. And another reason why we do the oral arguments, for example, is so that the judges can interact with the parties, can ask them the questions, because they have gone through the material, they have familiarized themselves with the case. You saw when the judges were asking Mashari advocate a question over and over and telling him, do you really understand what we want? And trying to emphasize, because that's the opportunity they have to...
votes,
exactly.
votes, yeah.
That's the interface they're able to have in the oral presentations. Then finally, the oral presentation is also important to lay the sequence. Because when you have the pile of papers, sometimes the judicial officer will be able to read what is there, but they may not be able to draw the line. So when you listen, for example, somebody like Senior Feroz Norji, or you're listening to somebody like Fred Ngatia, they're very good at that, in laying the foundation stone upon stone and building the case. Now, for somebody who had just read the matter and had not internalized it, when you listen to the oral arguments, you're able to see how one leads to another, leads to another, leads to another. Remember yesterday when we saw the presentation of the report by the IT experts. That's what it did, because we had had all these servers. But now when the report comes, there is something that you can reference and say, oh, so this is what you are alluding to. And now all this scrutiny of 34A, 34B, now join together with this scrutiny, and you will see what we were trying to tell you. So that's the place of oral arguments. But both of them are equally important when you're considering the matter, because we do not lead evidence like we do in the lower courts, where you call witnesses and they take oath and they give evidence. Here it's the advocates who have to do the work.
All right. There's the question of 6 judges, an even number, and in a case like this, you could end up with what would be a deadlock, 3-3, isn't it?
Yes.
Is another possibility?
Yeah, that's a possibility.
Then what?
If that happens, then the petition will have been lost. Because for you to win, you must get the majority of the judges sitting.
Wow, that's very interesting. One would think that...
Yes.
Because yesterday actually misled the country, and my senior, Jojo Mue, called me out on it and sent me a text and said, no, in this particular matter, it has to be a majority decision. The Chief Justice, even though he takes precedent, does not have a casting vote. And I told the nation that there's a casting vote. So I take that back. This is the correct position. If you cannot persuade majority of the judges that the petition is good, then the petition must fall. If there's a deadlock, then that means it falls.
Wow, that's quite interesting, is it not? I mean, some people will say, well, for you to lose the petition, you also need to lose by a real minority. But anyway, I guess the law doesn't quite work like that. Now, let's talk about what you perceive to have been the case of either side. What is that thing that when the judges sit, they're saying, okay, so this is what the petitioners are actually saying, this is what the respondents are actually saying. Because at the end of the day, I would imagine they have to summarize this and say, this is the case that the petitioner has made, this is actually the response that has come from each of the 3 respondents, Jotha.
Well, basically, the petitioner's contention is that the election did not meet the required constitutional and legal standards, whether looked at quantitative level or at qualitative level. When you talk about qualitative assessment, we are concerned about the environment in which the entire process was conducted. Was it free? Was it fair? Are there proof that any aspect of the election was not done properly? For example, were people free to vote? Are there people who were bribed? And many other similar considerations. And at quantitative level, we look basically at the votes. Looking at the entire elections, can you safely conclude that the president lawfully and fairly won, judging by the way the entire process was conducted? The argument by NASA, simply put, is that, number one, the election failed to meet the required constitutional standard and legal standards. They are saying that there were several irregularities, several non-compliance with the electoral law, to a point where it was not possible to tell who won. That was the main argument that was raised. And that is because, according to them, the way the entire election was conducted was not strictly in accordance with the Elections Act and to some extent the Constitution. And maybe I can just give a few examples because the arguments were so many. First is the argument that that the declaration was not made in accordance with the law. The law required that after the conclusion of the voting exercise, the votes would be tallied at the polling station, and then the results from 34A would be processed, it would be signed, it would be then relayed electronically to both the National and the Tallying Center. The National Tallying Center and the Constituency Tallying Center. And at the Constituency Tallying Center, the Form 34Bs would be prepared, which would then be relayed to the National Tallying Center.
Yeah.
So NASA's argument is that as at the time the declaration was made, some of these results had not been verified. According to them...
But there would be an argument about, I would imagine, perhaps even what verification amounted to, isn't it?
Mm-hmm. Because the decision that came from the court that the results that are announced at the Constituency Tallying Center are final meant therefore that the verification was supposed to be done at that point. So that the role that was left to the chief agent now, who would be the chairman, Chebukati, was simply to do the math. Just collect everything and tabulate. So that even if at that level, at the National Tallying Center, he noticed that maybe there was an error or an error was picked out, if that was the result that came from the Constituency Tallying Center, then that could only be overturned by filing a petition. And so the role, therefore, was very critical at the Constituency Tallying Center.
Have I not heard some people say that that is only one way of looking at it, that perhaps if the chairman was supposed to declare a result that is verifiable, that perhaps there was, I mean, like, why was the need put in the law or that the 34S should also come to the National Tallying Center? I would imagine that they would look at the 34As and say, truly these 34As are the
reflection of the 34Bs.
Yeah.
Yes, but now if what the IEBC had done before, when they issued the rules before they were challenged, is that they had reserved the right that if it came to the National Tallying Center and they felt that something was unverifiable or there was an error or there was something that they were not happy with, they would not accept those results, but would go ahead and investigate further before they made the announcement.
Okay, I'll take a short break and then we